responsibilities to a managerial employee status. And there is a bargaining unit had been established for that particular employee as a non-managerial employee. How would a change be affected from one's, how would one go through the process of elevating or changing that employee's status to a managerial position, hence non-protected?
Your Honor, the procedure that's been used for the last 30 years by the Public Employees Relations Commission is the employer files a unit clarification petition. And then at that point, the impartial neutral, which is the Public Employees Relations Commission, hears the evidence, and if the facts justify that, then the employee would be reclassified as managerial.
So this has to do, I presume, with your first issue, dealing with the Commission's exclusive jurisdiction to make determinations. And because there had been no such determination in this particular case, you're saying that Chapter 120 processes do not provide a remedy to an affected employee?
Well, not 100%, Your Honor. What I'm saying is that if jurisdiction or delegated legislative authority is delegated exclusively to PERC, then no other agency has power to exercise the same jurisdiction. So if an agency exercises that jurisdiction, then it commits an invalid exercise of delegated legislative authority under the Administrative Procedure Act. And if it does so, then the case never needs to go to a 120-57-1 hearing, which is a fact-finding hearing. It need only go to a 120-57-2 hearing, because the excess of...
What you're saying, then, the issue is simply one of law rather than one of disputed fact. Is that your position?
That's correct, Your Honor.
So once a determination has been made by PERC, and that determination has not been changed, it's your position, then, that the employing agency has no authority other than to honor that particular determination?
That's correct, Your Honor. Actually, the parties before PERC are the governor, the statutory public employer, and the employee organization. So as between those two parties, in every case that's decided by PERC on unit determinations, managerial and confidential determinations are made. And if you allow an individual agency, which has only a few of the employees, to make its own decisions, you essentially destroy the process that the legislature created to manage employment relations.
Well, if it were not for Rhea and Shuttle, would the process simply be the issue of an employee's status, i.e. managerial, non-managerial? Would that be exclusively the determination of PERC? Would there be a proceeding before PERC rather than before the employing agency, the public employer, as here?
Yes, sir. Your Honor, there would be. The agency, actually the governor, would be required to file a petition saying...
You're talking about the clarification petition,
yeah,
the unit clarification.
Unit clarification petition, which is the vehicle that's been used ever since the PARA was passed by the legislature back in the early 70s. So, well, in this case, the petition proceeded from the agency to the Division of Administrative Hearings, and the administrative law judge conducted an evidentiary hearing in August 2004, and in October determined that the employee did not perform managerial duties. Compared the duties after receiving the evidence, compared the duties she did perform against the statutory standard, and determined that she did not perform a significant role in the preparation or administration of budgets, which was the focus of the agency's case. In March of the next year, the agency issued a final order which reversed that ultimate factual determination and dismissed her petition. The preemption question is one of the major issues we think that are before the court. And as far as counsel can determine, every appellate district that has addressed this issue has held that the Public Employees Relations Commission has exclusive and preemptive jurisdiction over all issues which are arguably within the scope of Chapter 447, Part 2. That would include, I think, the 1st, the 3rd, and the 4th districts. The Supreme Court does not appear to have reached the question.
If there were no jurisdictional issue involved, then it would appear to me that these determinations would be repeatedly tried either before a hearing officer or before the employing agency as disputed fact questions, whether or not this employee's position was managerial, supervisory, or otherwise, hence no longer protected. I guess what your argument is that by adopting some type of bright line test, that once PERC has made a determination and that determination has not been changed by PERC, that there is no factual issue to be tried, which of course is your alternative fallback position under issue 2. This is a rather murky area of the law because we have a kind of a hybrid situation now in that Chapter 120 processes are available to an affected employee. And the employee then, as Ms. Fuller did, she presents herself before a hearing officer. And then the factual, that is the 12057(1) proceeding occurs. And we have an order which addresses, I believe actually I don't think the hearing officer addressed specifically the legal issue. Did he?
He determined not to do that, Your Honor. Yeah, I think
you considered that he was without authority to address it?
I think that he did. And I think he expressed that on the record. I think the reason the process was constructed this way, so that it is the governor, as the public employer, who has the option of clarifying units, is so that you don't have this multiplicity of actions where a third-party agency that had nothing to do with the certification of the unit can come in and change the composition of a bargaining unit, deprive employees of their constitutional right to be involved in collective bargaining, all outside of the legislative scheme designed by the legislature. So that
it seems to me that the Department of Education's brief agrees with you in part by suggesting that perhaps the proper way of handling this is simply to dismiss the petition for 12057 relief, and presumably, I don't know whether the recourse would be then to go back to PERC.
I don't think that it would at this point, because once the petition aims at the fact that the Department of Education exceeded its delegated legislative authority. That does give the employee a chance to file a petition because she is substantially affected by the invalid exercise of delegated legislative authority, to put it in statutory terms. And under 12057(2), the agency need only recede from its invalid exercise to correct the situation. That is, restore the classification decision to where it originated, and if the governor thinks it's appropriate, the governor can file a unit clarification petition.
Counsel, you have made the exclusive jurisdiction argument with regards to PERC. I'm wondering, could the employee have gone back through PERC? Is there a remedy through PERC for the employee?
I don't believe that there is a remedy, an individual remedy for one employee with PERC. So that I think the only thing the employee can do is what the employee did. That is, bring up the invalid exercise and have the and ask the agency to rescind its action. The
If the agency rescinds its action, does that put it, if the agency rescinds its action and puts it back at point 1, can the governor then go in and seek the modification?
That would be the appropriate
And the
procedure.
fact all of these findings of the hearing officer would not be binding on the question of whether this is managerial or not.
I would
have
like
no
to
impact on that PERC.
Yeah, I'd like to say something else, Your Honor, but I think that's correct. I think PERC could make a different decision, but the nature of these unit determination decisions is a bargaining unit is certified in 1975. 30 years later, things will have changed. So there has to be a mechanism for the employer to seek to change things. There has to be a mechanism for the union to seek to have
But
PERC.
you're saying that the only mechanism currently available to the employer under the circumstances is by a unit clarification petition.
I think that, yes, Your Honor, I think that's right, and that's because the governor is
PERC would have then the responsibility of deciding whether the employee was in fact an ordinary employee or a supervisory or managerial employee.
That's correct, Your Honor, and I think that's really appropriate because these questions involving managerial and confidential status remove a fundamental constitutional right from the employee who's found that way. They require special expertise. It involves the manageability of collective bargaining. So PERC is looking at things every day that have to do with what is the effect on collective bargaining, on the ability of the employer to maintain confidences and such and so forth.
Well, so then I presume that there are no res judicata principles involved here if indeed Ms. Fuller got the relief that she wanted, that indeed she remained a part of the established bargaining unit. You're saying that the governor then could, notwithstanding that particular determination, could go back before PERC to make a determination whether, not necessarily, we're not talking about individual employees, but whether the class of employees as such remain within the bargaining unit.
Yes, Your Honor, and that's the appropriate way to do it. I'm representing Ms. Fuller here. I wish that weren't so, but I think the law is that that statute, Chapter 447, Part 2, is a comprehensive statute which gets an impartial neutral into the middle of this bargaining relationship to ensure that the rights of the employees are protected and the rights of the employer are protected. Thank you.
Once again, we'll give you a minute to respond.
Thank you.
May it please the Court. My name is Daniel Woodry, and I'm here on behalf of the Department of Education. I think it is important for this case to understand a little bit the context. I actually strangely find myself agreeing with some of the points that Mr. Trainum has made, and we'll go over those. But the context is that the legislature chose to change the state's civil service system. And that issue has been litigated. That was litigated to this court. There were multiple challenges to the constitutionality of that change in multiple forums, as a matter of fact. As a result of that, the way the employee classification was done probably needs to be clarified. It's not just the Department of Education that was involved in this. Since the governor is considered the employer for purposes of the public employer in this context, the way it works is that the Department of Management Services is in effect kind of his designee for a lot of the administrative work, and the Department of Management Services ends up working with the Department of Education, the Department of Health and Human Resources that works with all of the different departments. So the way this classification was done, it was not as though the Department of Education said, you shall be this. It was, they asked for a list of employees who met the criteria. Those lists were submitted. Those lists are reviewed. A decision is made. Then this particular employee, Ms. Fuller, we're talking about here, she was notified that the position had been changed from the old classification as part of career service. She then served in that position for approximately 18 months. And as being part of SES instead of career service, she qualified for the state to pay her medical benefits, which was not the case before, other things as well. She was then let go by the Department of Education in, I think it was January 7th of 2003. And at the point,
because of her SES classification.
Because of her SES classification, as is common practice, she was let go, and there was no cause case made for letting her go. Now, there may very well have been a cause case, but the general practice is if somebody serves at the pleasure of, you have no need to make a case because they serve at the pleasure of. This court then issued its opinion in Rhine Shuttle in the summer of 2003. And as a result of the opinion in Rhine Shuttle, agencies provided notice of a potential, and I think it was couched as they may have an entitlement to a 12057 hearing.
Well, Mr. Woodring, it seems to me that if indeed the only remedy to an affected employee is a 12057 remedy, and 7,000 employees were affected by reason of the Service First legislation, it would appear to me that there would be repeated disputed fact hearings under 12057-1. Is that an appropriate way of making a determination of an employee's status?
Your Honor, I believe that's not the appropriate way, and I believe actually that there were several arguments on that. One argument is that because this was done by an act of the legislature, it was not just the employer determining we're going to change classifications. There's case law out there, and I think it was maybe initially argued in Rhine Shuttle, that the legislative process itself and the fact that you can lobby the legislature as to changes in the classification is considered to be due process that employees are entitled to. They're not necessarily entitled to individual due process because the legislature can, by a stroke of its pen, change the classification of a number of employees. I think the important issue here, though, is that there is a collective bargaining agreement that covered at the time the classification was done, Ms. Fuller. And under the collective bargaining agreement, there is a provision under there for notification when there's a reclassification. There was notification by the Department of Management Services acting on behalf of the employer that listed specifically all of the positions that were going to be reclassified. Under the collective bargaining agreement, there's a time within which the union is supposed to reply, and if not, they're considered to have waived it. There's apparently some dispute as to the whole process there, but the point would be if there's a dispute, that's a process under the collective bargaining agreement. I think the thing that's most important, though, is that that is not an individual right of an employee, which makes perfect sense when you consider this is a collective bargaining agreement. And part of the nature of a collective bargaining agreement is, well, let me give a hypothetical here. If the union, for example, had negotiated as part of the collective bargaining for reclassification of any number of positions, that reclassification may negatively impact employees within the unit who are being reclassified. The union may look at it as a benefit to the overall bargaining unit because of whatever they're getting. And in fact, there are cases from around the country where this is a situation. That does not mean that the individual employee has standing to challenge the classification of the members of the union. Same thing, the union might, in some circumstances, and in fact this is not uncommon, they might negotiate a pay structure that would be less than an individual employee could negotiate on their own behalf because of their particular characteristics.
I assume that your reference to the collective bargaining agreement refers to your argument on cross appeal that the employee waived her right under the circumstances by waiting one day too late?
Your Honor, I don't believe that's our exact argument. The argument is actually that the employee's right was waived to individually challenge because she was a member of the collective bargaining unit. And by being a member of the collective bargaining unit, she has collective rights, but except insofar as the collective bargaining agreement provides, she may have given up individual rights.
Well,
and
it's
that's
the union's responsibility. Now, there are some arguments in here in the brief of the employee, which were not responded to by the DOE, that under the collective bargaining agreement, it is the responsibility of the chief negotiator of the Department of Management Services to notify the union of the proposed changes. The person who indeed, the employee of the Department of Management Services, was never identified as the chief negotiator. That was evidence to that effect. It seems to me that if the department is going to rely upon the strict terms of the contract, it has to indeed comply with the terms of the contract. If indeed the chief negotiator didn't provide this particular notification, it seems inconsistent to me that the department would rely a one-day delay in a response by the union representative, not the individual employee.
Well, Your Honor, and I believe that was a little bit of the point I was trying to make earlier, that there are some disputes that appeared in the briefing as to exactly what happened in the notice of the classification and the response to that. But the point that I would make is that if there are disputes as to that, because that is provided for under the collective bargaining agreement, it is not for this forum and it is not as to this individual employee. In other words, if the union wanted to bring, assuming they'd met other requirements, an unfair labor practices charge against, as it were, the state employer, saying you didn't give proper notice, it wasn't from a chief negotiator, they may have had a basis to do that.
Isn't there a well-defined procedure before PERC whereby the employer, in this case the Department of Management Services, can simply file a unit clarification petition if indeed it believes that a certain classification of positions no longer exists, that they no longer fall into the exempt category? Why not go back before the commission which established those classifications, place them into a bargaining unit, rather than simply have an employer, or rather the public employer, make that particular determination by providing notice? It seems to me that you've got a defined procedure which is established under Chapter 447, and that I don't see anything in Chapter 110 necessarily divesting PERC. And indeed, there's a reference, as you well know, under Chapter 110 establishing this legislation that refers to Chapter 447
to the definitions
processes.
Yes. Well, Your Honor, I believe there are several answers to that. There is a unit certification, unit clarification process. That is not the only process that's used to reclassify positions. And an example of that would be the legislature had determined, and you have to forgive me because it predates my history with the state, that agencies were allowed to classify a certain number of positions as a select management, SMS or SES, and that discretion was given in a law that was before the change to 7,000 positions. The key here, I believe, is that if we're talking about an agency reclassification in the absence of legislative action, you are correct as to there being a clarification of the unit, a certification, but in this case, the legislature changed a number of things. Now, managerial and confidential, those were terms that they referred to Chapter 447 because those were terms that were defined in Chapter 447.
Well, wasn't that the only issue before the hearing officer below was Ms. Fuller's status, whether she was a managerial employee or not?
That is the issue that was argued before the hearing officer below. We had raised the issue that the hearing officer never really was in a legal position to reach that issue because being part of the collective bargaining unit, she didn't have a right to raise that individually. And let me explain a little bit why that
in
is.
reference to the agency's reclassification, do you agree that the Service First enabling legislation recognizes that PERC has been delegated the responsibility to define managerial employees for bargaining unit purposes?
I agree that PERC has been delegated under 447 that. Under the provision in 110, though, the reference is not that the determination shall be made by PERC. The reference is in two positions there that the definition of managerial in 447 is the definition that shall apply, and the definition of confidential. There's a third category there, which is supervisory, which was the other major category that was added. That is defined within the provision in 110 because there was no existing supervisory definition under 447. So I look at that as only importing the definitions, not saying PERC was the only one that had to make those decisions.
The difficulty, though, is that the employee here, the issue was whether she was a managerial employee, and the Chapter 110 referred to Chapter 447 to supply the definition of managerial employee.
Yes, Your Honor.
Which seems to lend some credence to Mr. Trainum's argument that PERC does indeed have the exclusive jurisdiction in certainly determining the status of a managerial employee.
Well, Your Honor, I believe that he also expressed that the employee doesn't have an individual right to that determination under PERC. And that, I believe, is more our point in that, and this case is, it is Ms. Fuller versus the Department of Education. It is a case as to an individual. And that's why we've asked the court to either affirm the final order of the agency or, in effect, vacate the entire proceeding. And as I
vacate it for what purpose?
Basically, vacate it because this employee doesn't have an individual right to a 120 determination as to the position.
And what remedy then would she have?
The remedy that she has is whatever remedy she has as a member of the collective bargaining unit. As we mentioned, there are going to be situations and there are cases out there where an individual employee is actually negatively impacted by the collective bargaining agreement.
I could agree entirely with you. It'd be much cleaner. But there's Ryan Shuttle out there.
Well, Your Honor, there is Ryan Shuttle. We have not asked this court to recede from Ryan Shuttle because I truly believe that Ryan Shuttle is distinguishable, and here's why. And Mr. Trainum was counsel in Ryan Shuttle, and so I'm sure he can answer this as well. From pulling the briefs in Ryan Shuttle and looking at the briefs, this court did a succinct opinion, and they said other issues that were raised have been rejected. From my reading of the briefs, the preclusive effect of being a member of a collective bargaining unit was not an issue that was briefed and that was reached and that this court ruled on. So I believe that Ryan Shuttle, based on what was presented to this court, which is all this court can work with, I believe Ryan Shuttle was a correct determination. I believe if in Ryan Shuttle the issue of a collective bargaining agreement that covered Mr. Ryan Shuttle, covered the others, if that had been raised and had been argued.
All I can do is do as any other person out there who reads an opinion of this court or any other appellate court, where it says we agree that appellant should have been provided a point of entry, i.e. via 120 processes, into the administrative process when their positions were reclassified as selected exempt. And then the opinion continues. We have considered all the other various issues, which were not stated in the opinion, raised by the parties and find that they are without merit. So I'm sorry. I think we have to rely upon the language, and it appears to me that indeed, based upon that language, there is a remedy available to an affected employee via Chapter 120.
Well, thank you, Your Honor. I would again ask that, and I believe on that last point, I'm not saying that Rhine Shuttle was incorrectly decided on the facts before it, but Rhine Shuttle actually only dealt with, and I think it was a consolidated of 4 or 5 employees who were actually part of the Rhine Shuttle case. If the issue, if the defense, if the issue of there being a collective bargaining agreement that covered those rights was not raised before this court in Rhine Shuttle, that was a deficit, but that does not bind the court in this case if a different defense is raised. Thank you.
Thank you. Mr. Trim, you have 1 minute remaining.
I'll make it quick, Your Honor. I'd just like to point out that the legislation, the Service First legislation, did not change anything with respect to the units that were certified by PERC. That is, every unit that's at issue for this particular union were defined by PERC 24, 29 years ago as excluding managerial, confidential, and supervisory employees. It was done both in adversary proceedings with the governor, and it was also done by what was called unit determination by rule, in which they were, every one of them had those exclusions. The second point I just wanted to point out to you that in the unit clarification proceeding, and I believe this court has dealt with it, but I cannot recall the case right now. When a unit clarification petition is filed and a managerial confidential determination to be made, the particular employee who's involved in that determination is notified and given an opportunity to come before PERC and have their say. Thank you, Your Honor.
Thank you very much. As I announced earlier, we'll be